All right, we have one day on ethics, and I don't try to reteach your professional responsibilities class. The only thing I really want to do is identify a few unique aspects um, to the estates and trust practice. All right, so from last class, I tend to give you a one slide review. What I need you to know from last class is that you need to be able to look at a list of assets and identify them as probate or non-probate. Remember, we looked at a few cases. We dealt with the green case on Totten Trusts. We didn't actually have a case on the joint account. The key is that law has really changed, and there is a presumption favoring survivorship. So by adding somebody's name to an account, there is a presumption, rebuttable, but presumption favoring the surviving tenant. And thirdly, we need to think about title. This will also be relevant in terms of our inter vivos trusts, but we got a little bit of property on day one with life estates, followed by remainders, okay? And so at death, the painting was already given to the son. Why? Because he had a remainder interest, and therefore it could not pass by intestacy, because intestate succession only controls probate assets. All right, so in terms of ethics, there's two major components that I want you to think about, and that is identifying the client. You have an attorney-client relationship, and identifying the client is sometimes difficult in the estate planning arena, particularly when you have the family lawyer who's representing multiple clients, or you're representing husbands and wives. Remember, the attorney owes fiduciary duties to the client. So that's why we need to make sure that we have a proper client identification. Again, this chapter sort of picks up on what it means to be an estates and trusts lawyer in terms of the big three, mostly estate planning and estate administration, but estate litigation is a growing area of practice. When you meet with the client, it is very important to get an understanding of the starting point. How plan that you prepare, deviate, improve from where they are. And that's where sort of understanding if they don't have a will, this is their first will, you might talk to them about what would happen under the laws of intestacy. The elderly client presents a whole host of issues, particularly if they're being brought to your office by a beneficiary who happens to be paying for the services. Maybe you happen to be the attorney for the payer. So those are some issues that you need to make sure you separate the client from the beneficiary, even though the beneficiary, in this case, the daughter, might be the driving force. The married couple presents a whole host of issues, particularly as we look at something called the elective share. The spouse is the one person that cannot be disinherited. So if you represent the couple and the estate plan does not provide adequately for the spouse, you need to make sure that there's waivers signed. Or if the spouse is ultimately appointed as personal representative, keep in mind you will not be able to represent that spouse in both capacities. The one case that we look at is the case of the family lawyer, where one lawyer is representing many people. We also have a situation in which what happens if you prepare the estate plan for the married couple and then later one of the two come back to you and want to make a change. You have to make sure that you represent them as a team. Joint representation is key. And as a result of representing them as team, which you have documented in writing, you pick up the phone and you notify the other party when someone comes to you about wanting to change the estate plan that impacts your other client. All right, let's take a quick look at Holtz v. Minyard and some of the things that I need you to make sure that you have after having read the case. Do you understand the key difference between what I will call the AM will and the PM will? Do you understand with whom did the attorney have the client relationship? What is the relationship between the attorney and the daughter? And did the attorney have an obligation to give daughter father's will? What would you have done? Those are the things that I want you to think about after you've read that. The key difference between what I'll call the AM will and the PM will is what the father did with the real property upon which the Greenville dealership was operating. And that was the big key. So by making a specific bequest to the son, that takes it out of the residual that is then divided between Tommy and Judy. The next major issue in terms of ethics is liability to third parties, liability to non-clients. How can that be possible? Why are we even talking about that? Well, because our client is dead. And basically, if our will speaks at death and we are only liable to the decedent, then we would never be at risk for a malpractice claim. And in fact, our insurance should be much cheaper in Maryland because Maryland adheres to the strict privity rule, meaning we do not owe a fiduciary duty to the beneficiary, only to your client. The Barcelo case is a Texas case, and that case also adheres to strict privity, understanding who the parties are, what happened as a result of the estate plan pouring over to the trust and the trust not being valid. It defaulted back to probate, but there was nothing that the will had done. What might you have done to improve it? And then finally, we get a chance to look at two Maryland cases. The Noble v. Bruce case, sort of understanding the estate plan, understanding that what the children were complaining about, and what does Maryland think about the balancing of factors test. Also within that case was the Ferguson v. Kramer case. And again, the residual legatee is being stuck with the tax bill because of a tax clause. Should the lawyer have included the tax clause? Was that negligent? If that was negligent, to whom was the duty owed? And if that was negligence, there was a breach, and what are the damages? So those are the issues that we're talking about. Again, one day on ethics, not a big component of this course. Take a look at the balancing of factors test, which in fact is what the majority of jurisdictions use. All right. See you soon.